everyone, karibu tena to another episode of Know the Law with Advocate Kyumwa, where we discuss legal matters in simple language to help you understand your rights and make informed decisions. Remember, justice starts by first understanding the law. Today's topic is one that affects every family or everyone at some point in their life. That is, the right to own property in Kenya and the law on how to deal with the property of someone who is deceased. I know it is hard to imagine death, but have you ever imagined what would happen to your property after you die? And more importantly, do you know how to make sure your property ends up in the right hands? Well, today we will break this down, guided by the law on ownership of property in the country and the law which deals with how to deal with the property of someone after they die. Article 40 of the Constitution of Kenya provides that every person has the right to acquire and own property anywhere in the country, either individually or in partnership with others, and such right cannot be arbitrarily deprived from them without a just reason. And in case the government tends to obtain or acquire the right of that person, they have to acquire it justly using the right procedure, and they have to adequately compensate the owner of that property. This right to own property applies equally to all men and women, whether married or unmarried, and even to children born in or out of wedlock. Property in itself, it encompasses a lot of things. It includes land, intellectual property, personal items, movable and non-immovable items, and anything which can be owned is contained in the definition of property under the laws of Kenya. In marriage context, how the property will be dealt with after death, it depends on whether the property is owned jointly by the couple or it is registered in the individual name of one of the spouses. If the property is jointly owned by the couple, the property automatically, upon death of one of the parties to the marriage, the property goes to the surviving spouse, and therefore it is not available to be dealt with according to the law of succession. However, if the property is registered in the name of one of the spouses, it forms part of the estate, and if that person who the property is registered in their name dies, the property is distributed either following a will, if that person left a will, or in accordance to the succession laws of Kenya. According to the law, the property of a deceased person would be dealt with if they left a will the property will be dealt as per the will. But if such a person did not leave a valid will, such a property would be dealt with in accordance to the laws of succession. And this takes us to understand that there are two types of succession. That is the testate succession and intestate succession. In testate succession, the deceased person has left behind a valid will, and the executor of the will applies to court to have the court confirm the will and allocate the property as per the wishes of the deceased person. We will discuss details on the valid will and their advantages in a separate episode for you to be able to understand what amounts to a valid will and why you need to leave behind a valid will. On the other hand, intestate succession is whereby a person dies without leaving behind a will, or leaves behind a will which is later on declared null and void or invalid, and therefore the estate has to be administered or has to be dealt with in accordance to the applicable laws of succession in the country. In intestate succession, distribution of the property of the deceased depends on the family structure, that is, the number of spouses left behind, children, and whether they are extended relatives. And now this one takes us to discuss on who amounts to dependent for purposes of inheriting the property of a deceased person. Under Section 29 of the Laws of Succession Act, dependents include a spouse or spouses, children who can either be biological, adopted children, if the deceased was providing for the children before their death. Parents and grandparents are also recognized as dependents if it can be proved that we used to rely on the deceased for provisions. Also, grandchildren and siblings of the deceased are also recognized as dependents. But the law provides there must be proof that such a person used to provide for such persons before they died, and also it provides for hierarchy of who is entitled to inherit, and therefore someone can only inherit the property of the deceased if the person who lies ahead of them in priority is not available to claim the inheritance. The spouse of the deceased ranks first for purposes of inheritance, and if the spouse is also deceased, the children come next. The person died without leaving behind children. Now the next level we go to the parents of the deceased. If the parents are not there, we go to grandparents and all that in that chain. Therefore, for one to come and claim from the property of the deceased person, they must show proof that ahead of me there is these people who were entitled to inherit, but the person did not leave behind a spouse or did not leave behind children, or they have to prove that before the death of that person, they used to be provided by that person. So they must prove dependency. Children who are born out of wedlock, as I have discussed, they are also eligible to inherit if it can also be proved that the deceased used to recognize them as children. And therefore, this comes in to cure the problem of, let's say, someone at the time they married the deceased, they had children. If this person adopted the children, or took in the children and accepted to be their father or accepted to be their stepmother, such children are eligible to inherit from the property of the deceased. No one, not even a widow, a child, or a brother of a deceased person is allowed to deal with the property of a deceased person without first obtaining letters of administration or probate of a will. This means that once a person dies, no one has capacity or has a legal right to deal or transact with the property of the deceased without first applying to court to obtain letters of administration or probate of a will. Therefore, any sale, lease, or transaction of whatever manner involving such a property before a grant is issued or confirmed is illegal, void, and it may attract criminal charges. Any person who deals with the property of a deceased person without obtaining the letters of administration or propounding the will, such a person is guilty of an offense known as intermeddling, which is criminal in nature, and they can be fined and they can be sentenced. Therefore, it is the law that once someone dies, their property can only be dealt with upon obtaining letters of administration or probate of a will, if there was a will left inherit. The next step is for the administrator to now gather all the family members together and start the process of the succession, all filing for the letters of administration. To file for the letters of administration, the first step is the administrator has to obtain a letter from the area chief, where the letter serves as an introduction to court on the beneficiaries who were left behind by the deceased, and also a confirmation to the court that the deceased was well known by the area chief before their demise, and that before they died, they were residents of that area or locality. This helps for purposes of confirming the jurisdiction of the court. The next requirement is the administrator has to, after now they obtain the letter of the area chief listing the list of the persons, all beneficiaries who were left behind by the deceased, the administrator has to obtain the copies of national identification cards of the persons listed in the letter of the area chief, and obtain original death certificate of the deceased. And as we have said, the properties of the deceased which he has already collected or tabulated their list, he has to go to the lands registry and obtain official search of the property or the properties of the deceased person, and that means all the properties. The administrator should not leave behind any property of the deceased person unlisted for purposes of administration of the estate. Once the administrator obtains all those documents, they now have to engage an advocate, present all the documents, that is the letter of the area chief, the original death certificate of the deceased, copies of national identification cards of the persons listed as beneficiaries in the letter of the area chief, copies of national identification card of the persons who have accepted to stand surety to the administrator, and the original certificate of official search of the properties of the deceased. Once the administrator submits all the documents to an advocate, the advocate prepares the application documents for the letters of administration, facilitates or guides the beneficiaries and the administrator to sign the application documents, attaches all the annexures, all the required documents, and once all the documents are duly signed, the advocate files the applications in court. The application, once it is filed, the advocate pays the assessed fees. After the payment of the fees, the case is issued with a filing number. Thereafter, the application is taken for gazettement at the government printer. Gazettement of the application for letters of administration is important because it serves as a way of notifying the public that the estate of the deceased person, the family has appointed an administrator where the name of the administrator is listed in that gazette notice, and also requires members of public, any person who has any reason to object to such letters of administration being given to the proposed administrator, to raise such an objection within 30 days from the date of the gazette notice. Therefore, the gazettement is very important. If after the lapse of 30 days from the date of gazettement of the application for letters of administration, no one has raised any objection in court, the court now proceeds to issue the letters of administration to the person who was appointed by the family to be the administrator of the estate. And the letters of administration, they are known as letter 41. Many people know it as letter 41. And these letters of administration does not give the administrator the right now to start selling or dealing with the property of the deceased. It only gives the administrator the power now to take count of the property of the deceased, to collect, to take list of all the creditors, all the debtors, and be able to collect the family together to have a family meeting and agree on how the properties of the deceased shall be distributed. At this point, the family can, after it has agreed on how the property of the deceased shall be distributed, they can engage a surveyor to check out the measurements of the property and informally demarcate the portions as per what the family has agreed. This report, all the agreement of the family members on how the property shall be distributed, the administrator has to submit it to the advocate who they have engaged to help them in the process of administration. And now the document is submitted by the administrator on how the property shall be distributed, shall guide the advocate in preparing the final bunch of documents to be filed in court for purposes of confirmation of the grant. The confirmation of the grant usually takes place after 6 months from the date of issuance of the letters of administration, and at the hearing of the application for confirmation of grant, all the beneficiaries of the estate have to be present in court, and the court has to be satisfied that the distribution of the property is submitted to the court with as annexed to the application for the confirmation of the grant. All the family members are agreeable to the property being distributed in such a manner. If no family members is objecting to the filed mode of distribution, the court proceeds and issues to the administrator a confirmed grant. The confirmed grant now gives the administrator the power, the full power now to legally sign all the documents for transfer of the property of the deceased person to the legal beneficiaries as provided in the certificate of confirmed grant as issued in court. If during the hearing of the application for confirmation of grant, some of the beneficiaries are not satisfied with the mode of distribution, or they have objection to certain people being included as beneficiaries of the estate of the deceased, they can raise an objection, or they can raise their objection verbally in court, or they can put it in writing, and the court, if someone objects, they have to listen to their issues, determine the evidence as provided by such objectors, and finally make a determination on the issue. This helps to ensure that the rights of all the beneficiaries are well taken care of, and if there is any person at the point of filing of the applications for confirmation of the grant who has been unjustly been left out, this gives them an opportunity to be well provided in accordance to the law. After the grant is confirmed, it is the work of the administrator to go ahead and ensure that the property of the deceased is now distributed or transferred to the rightful beneficiaries. They have first to work with their advocate. The advocate will prepare the documents for registration of the confirmed grant. The advocate will be able to prepare a document which will be registered at the lands registry, which transfers the property from the deceased person to the appointed administrator, so that once one conducts an official search, the property is in the name of the administrator, holding in trust for the listed beneficiaries as ordered by the court. After that, the administrator has to make an application for consent at the lands board for consent for subdivision of the property or properties of the deceased person into the number of portions as per the confirmation of the certificate of confirmed grant. After obtaining the consent for subdivision, the administrator now can engage the surveyor to finalize the process of survey and subdivision of the property or properties of the deceased person, so that now the properties can be given or registered to the respective beneficiaries as per the certificate of confirmed grant. With that, once everyone who is supposed to inherit the property of the deceased person obtains their property and the documents to confirm that they are the rightful owners of such property, the administrator would have executed their duty to some extent, and after that they are supposed to file a report with the court on the administration of the estate to guide the court to understand that the administrator has justly done what the court ordered. Now, having looked at what the law provides on dealing with the property of a deceased person, I want us also to look at the process of now filing the succession, or the process of filing in court to obtain letters of administration, where that person has not left behind a will. The process starts by the family has to agree and appoint an administrator. An administrator is that person who is appointed to be the trustee of the estate of the deceased, or to be the representative for purposes of collecting the properties of the deceased, maintaining them, and signing any document which is required to be signed. Remember, a deceased person cannot sign a document. And for the ownership of the property of the deceased to move from their name to the surviving beneficiaries, someone has to sign the documents. Therefore, an administrator comes in. After the family appoints an administrator can be a beneficiary of the estate of the deceased. They can either be the spouse, the surviving spouse, or spouses of the deceased, or children of the deceased, or any other person who the family appoints or consents to them being appointed as an administrator. The law provides for the preference given to the people who can be appointed as an administrator, and it provides the surviving spouse or the spouses of the deceased in the first ranking position to be appointed as an administrator. Thereafter, we have the children of the deceased and other beneficiaries, a public trustee, all creditors. They can be, all those can be appointed as an administrator or administrators for the estate of the deceased. For one to qualify to be appointed as an administrator, that person must be of sound mind, must be 18 years and above, and must not be bankrupt. Minors and persons of unsound mind, they are disqualified from being appointed to be administrators of the estate of a deceased person. The number of administrators who can be appointed in a transaction, they should not be more than 4, and in cases which involve minors or a trust, there must be at least 2 administrators who are appointed, and this helps to protect the interests of the minors and to ensure that the administration of the estate of the deceased is undertaken diligently and in accordance to the law. Next, the family has also to appoint sureties who give guarantee that they would oversee the proper administration of the estate of the deceased. And the sureties, they are the ones who are liable if the administrator mismanages or misappropriates the assets of the estate. And therefore, sureties come in to hold the administrator accountable of all their actions and ensure that the administration of the estate is undertaken as per the law, and also the property of the deceased is distributed in accordance to what the court has ordered. The administrator is a very key person in the estate of the deceased because they have several duties. They have the duty to gather all the properties of the deceased and protect all the assets. They also have a duty to pay all the debts, taxes and liabilities of the deceased person. Also, they have a duty to distribute the property of the deceased to the rightful beneficiaries in accordance to what the family has agreed or what the court has ordered. And finally, the administrator has a role to file estate accounts and returns to the court to show the status of the implementation or the status of administration of the estate of the deceased. The administrator, in their capacity, as we have discussed, they are there as a representative of the estate of the deceased, and they are supposed to carry out their duties diligently and in accordance to the law. However, an administrator must not sell or transfer the estates or the assets of the estate before the grant is confirmed by the court. They should not be involved in favoring certain beneficiaries or misrepresent to court on the beneficiaries who were left behind by the deceased person. They should also not use the assets of the deceased for their personal gain or omit or conceal beneficiaries. This is because they are there as trustees of the estate, and it is expected that they will carry out their duties in accordance with the law. If an administrator misuses their powers and acts in contravention to their duties as provided in the law, the beneficiaries of the estate can hold them accountable by filing a petition in court for them to be substituted as an administrator, or they can also file a complaint with the police for intermeddling with the property of the deceased if the administrator is selling or in any way transacting with the property of the deceased without obtaining the confirmed grant or against the provisions of the confirmed grant. As I have said, intermeddling is a criminal offense punishable by fine or imprisonment in Kenya. Having listened to this informative discussion on the right to own property in Kenya and the law on how to deal with the property of someone who is deceased. You are now aware that everyone has a right to own property. However, when death comes, that property must be handled legally. Don't wait. Understand the law, educate your family, and protect your lovely family and beneficiaries. If you have any questions about succession administration laws or how to file succession calls, kindly reach out. I'll be happy to help you. Don't forget to follow and subscribe for clear and simple legal insights straight from my desk to your screen. Until next time, justice starts by first understanding the law. And this has been Know the Law with Advocate J.M. Kyumwa. Thank you.